Everything you need to know about products and services that can improve your life. This is Experts on Call on CL 650.
Welcome back. I'm Tony Giventu, your host of 650 CIL Talk About Strata. Adrian Murray, a lawyer with Hammerberg and Partners, is in the studio, and we're talking about hearings, which is kind of a complicated thing, I think, for most strata corporations to understand. Strata councils are volunteers.
Exactly, and it sounds serious. It's a hearing, and it should be considered seriously, but it's not so hard that it should be avoided. And I think that's sort of what we were talking about is strata councils may be intimidated a little bit by it. They set some parameters around it that are almost impossible to meet. 5 minutes and that's it. And that really misses the point of what a hearing is, particularly the hearing that we've been talking about, which is a hearing requested by an owner in respect of an issue. And the issue could be one of many. But then, of course, we also have hearings permitted under the dispute resolution processes of the Act. So under Section 135 of the Act, if a strata council wants to fine an owner for breaching a bylaw, a couple of things have to happen. They have to have received a complaint, and they have to provide the particulars of the complaint to the owner in writing, and they have to provide the owner with an opportunity to respond, including requesting a hearing if the owner wishes. So that should be in the letter that's sent to the owner, and then the owner can respond by providing a written response, or they can request a hearing. The definition of a hearing is the same. It's an opportunity for an owner to be heard at a council meeting. But here it's a little bit different because we know why the owner is attending. This isn't to make a request of council. This is to respond to council's letter to them about a complaint that the council has received regarding a bylaw. So what you'd expect to see at a hearing under Section 135 is the owner coming in with some explanation about what may have happened that generated the complaint, or a request that special permission be given to the owner. I'm thinking in terms of, if the complaint was my car was parked in visitor parking, I may have a reason for that. It had a flat tire, and that's as far as I got. The complaint was about noise. I may say, no, that wasn't me. Right. I didn't make the noise. I may, as the person being complained about, want more information about the complaint. I want to know who's complaining. So the hearing process will be a little bit different now. It is a little bit more adversarial.
So the test has changed a little bit, though, because Section 34 says provide an opportunity for a hearing, whereas Section 135 imposes the word reasonable. It introduces the word reasonable opportunity here for a hearing or to respond in writing. Is there a difference between the two?
Well, I think the word reasonable it's there. It has to mean something. And what the Act actually says is that they have to give a reasonable opportunity to answer the complaint, including a hearing. So if I write to the council, or I respond to the council's complaint letter, and I say I want a hearing, I think there's a greater requirement for that hearing to be held at the mutual convenience of the parties. This hearing under Section 34(1), I want the hearing, the council says it's at our next council hearing next Monday at noon. The owner may need to accommodate that. In this case, with the requirement that I have a reasonable opportunity, I think there has to be a little bit more accommodation to the owner's schedule in order to provide them with that opportunity to provide the evidence to the council that they think is necessary.
Well, and the dynamics have changed. We're now accusing them of something that they may be fined for, that could be quite substantial, that could have quite significant repercussions for them. So this is its own little judicial process.
Absolutely. Absolutely, and it should be treated that way. I think it's a serious matter. When you look at the we always look to fining, but there are other things that a strata council can do to enforce bylaws, including denying owners the right to use recreational facilities, removing items off of common property, requiring owners to pay the reasonable costs of repair. So it can be immensely significant to that owner, depending on what the outcome is, I mean, including even a $200 fine, which is the maximum amount of fine. If it's a rental bylaw, it's a $500 fine. So it's significant, and it has to have that level of seriousness around it when the council's holding the hearing.
So we're holding a hearing now. Do the dynamics, because this is a bylaw hearing, a change as to who can attend the hearing? Because the standard bylaws actually do not allow observers to attend a hearing or a portion of a meeting that deals with the enforcement of bylaws. So now this is a hearing about a bylaw enforcement issue. Is that going to change the dynamics on who can actually attend the meetings?
Well, I don't think, certainly observers are not permitted, and I'm not so sure that we would want observers in the other hearing as well. I mean, I think that it's reasonable for the person making the request to say, this is a matter, I mean, they may want observers.
Right.
If it's the leaf blower, they may want, everybody in the building to be there to listen to the issue. But that will really be driven by what the nature of the request was. In the case of a bylaw enforcement hearing, no, there shouldn't be observers. But now the dynamics change because the individual may absolutely want their lawyer there. They may have witnesses. They may want the person who made the complaint to be there so they can question the owner. And here's one of the situations I've run into. There's a complaint about excessive noise. And I receive a letter from the council telling me that there's a complaint about noise. I've got a reasonable opportunity to respond. But if they haven't indicated to me, well, what was the noise and when was the noise? And was it the sound of loud music playing? Was it the sound of, something being dropped on the floor? Where was it coming from? It may not have been me. Exactly what date and what time? Perhaps I was away. It might be the people next door. Until we get to the bottom of it, and if the council hasn't asked all of those questions, then it may be incumbent upon the person being complained about to ask those questions and to get to the bottom of it. They may also want to get witnesses to be able to say, we were next door, we were in the adjacent suites, there was no unreasonable noise, whatever the complaint may be. So the nature of the complaint will drive a little bit who we would expect to see at the hearing
process. So an owner, a strata council, fines an owner for, let's say, driving into the garage gate and doing damage to the gate. So there's a fine, there are damages to the gate that they're going to want to recover. They send notice. How they send basic particulars that it was, witnessed that you drove into the gate on Saturday night at 11:30 p.m. It's done $700 damages. We send off all this stuff. The owner says, it wasn't me. I wasn't driving my vehicle. How do you have any evidence that you can prove? We change the dynamic a little bit now, and we have a strata that has video surveillance in their gates and their entries and their exits and those types of things. As an owner, am I entitled to scrutinize that evidence as well?
Absolutely.
So that's the particulars of the complaint.
That's the evidence that the council is considering in making their determination of whether there's been a bylaw breach. So we come back to the idea that it's somewhat adversarial. I've got evidence on one side that says you have breached a bylaw, and that evidence may be eyewitness evidence, it may be video surveillance evidence, it may be the dent on your car,
the broken headlight glass that matches,
and the paint on the gate, all consistent. So there may be a variety of
right.
Evidence. Well, the owner's entitled to know what evidence the council has and possibly refute it if possible.
Right. So, but do the particulars of the complaint including the person who complained?
I think that's always a very difficult question, but I think sometimes it has to be. Because if the nature, and I describe it this way, if the bylaw says I can't have a freezer on my balcony,
right.
no appliances on my balcony, and I've got my freezer on my balcony, anyone can walk past, see my balcony, and see the freezer there. So it's not who's making the complaint is irrelevant.
Right. It's evident.
It's evident. A picture, somebody's cell phone picture, will be
right.
able to establish the evidence that shows the breach. Where we've got issues of noise, that's a little trickier. Is it the person above me, below me, beside me? is because that will go to the issue of whether it's really me that's making, particularly if I'm saying, no, I didn't have a party, I'm not making any noise, the loud music isn't coming from me, or
Right.
I may be even saying I wasn't home at the time. So we need to know, to get to the bottom of it, where the complaint is coming from. And I think in that case, yes, we need to know the complainant.
And those types of complaints are frequently noise or your pet did the following. It's often connected with pets as well. That, you know, the pet, you know, Jane Smith's pet made a mess in the hallway and it cost money to have the carpets cleaned and there was damages and the pet was running loose. Who witnessed that? You know, right?
Absolutely. And I want to know, and I may want to cross-examine the witness to say, well, what did the pet look like? Because they may have my pet confused with someone else's.
Right.
So no, that those will become important pieces of this hearing process.
So here's an email that I think helps us kind of with the bylaw hearing process. So it's a strata that has voted to ban smoking. And the owner smokes his odd cigar out on his balcony. Never smokes in his apartment because he doesn't want any of the residue from the cigar smoke to be in his unit. You know, when he bought his unit, there were no such rules. And now the rules have changed, and it's an infringement on his personal freedoms to smoke the odd cigar out on the balcony. He's now got a fine for smoking a cigar out on a balcony. The Strata has given him notice of it, told him that if he does it again, he'll get a $50 fine, gone through the process. So he requests a hearing with the Strata Council, and you know, it's pretty much the same debate as the nature of the complaint. You know, he wants to know why he can't smoke a cigar out in his balcony.
Well, and if in fact the bylaw has been passed, and if it's been passed by a 3/4 vote, and if it's been registered in the Land Title Office, and it says no smoking on balconies, that's pretty much the end of the matter. And so the owner can request a hearing, and I think, you know, the owner requests a hearing to want to know why he can't smoke. I think the very short answer is because there's a bylaw, and I don't think it's incumbent upon the Strata Council to have to defend its actions. I don't think it needs to defend the bylaw. That was approved by a 3/4 vote of the owners. It doesn't need to defend enforcing the bylaw because that's the Strata Council's job. So they can hear the owner. They can, if the owner wants to claim that he doesn't like the bylaw, he's certainly welcome to do that, but it doesn't change anything at the end of the day. And I think owners need to realize stratas are democratic beasts, and in a democracy there's a majority and a minority, and at any given time I may be part of the minority. I may not like the decisions that the majority have taken, whether it's a majority by 50% plus one or it's a majority by 3/4, but I have to either accept it or I have to move, quite
Well,
bluntly.
and we do have to state the obvious here, which is he's not smoking in his unit because he doesn't want the tar and nicotine in his unit, but
Slight ironic.
a slight irony there, other people who are upstairs whose doors and windows may be opened because they don't know he's about to smoke on his balcony will be getting the tar and nicotine in their units.
Absolutely.
Right. But then that's the whole nature of many bylaws that deal with lifestyle is they're often about nuisance. Right? They're often those types of things. Even if the Strata adopts a bylaw with respects to prohibiting smoking anywhere on the premises, the question is not necessarily have you smoked in your strata lot. The question is the smoking in your strata lot contaminating other strata lots, causing a nuisance?
That's essentially what bylaws are about.
Right.
I mean, we're not terribly concerned about what you're doing to your health if it didn't upset or affect anybody else, but it does affect other people. And the smoke does carry, and it's, in fact, interestingly, smoking is probably one of the hottest issues today in stratas, and more stratas are passing bylaws prohibiting smoking on all common property, limited common property, and many are going as far as saying no smoking inside strata lots.
Well, in older wood frame construction buildings that don't necessarily have good interior ventilation, or they have multiple ventilation systems connected, the smoke contaminates multiple strata lots frequently. And
Absolutely.
so it is a bit of a problem.
Yeah.
This is Tony Giventu. I'm your host of 650 Sea Isle, Talk About Strata. And we are talking about bylaw enforcement, and we're more importantly talking about the hearing process. I have Adrian Murray in the studio with us. We've been talking about the Civil Resolution Tribunal. If you would like to follow what's happening with the Civil Resolution Tribunal and the updates that have occurred this week in the legislature, go to the website www.civilresolutionbc.ca. That's one great way of following what's going on, paying attention. If you have a question and you would like to email us, you can email me directly at tony@choa.bc.ca, and we'll be back in a few minutes with a few more emails.
There's still more ahead with Experts on Call on CL 650.